For analysis on those big trials in Wisconsin and Georgia, let's bring in criminal defense attorney Joseph Tully. Thanks for being with us. Let's start in Kenosha, where we just saw Ellison, the Rittenhouse trial. Jury set to begin a fourth day of deliberations. Is this unusual for a trial like this?
It's not unusual at all. There was a lot of evidence here, a lot of testimony, and the jury by this point is well aware that this is a very critical case and that there will be repercussions no matter what their verdict is, no matter what side their verdict comes down on. So they're taking their time, and I'm sure there's a lot of emotion in that jury room.
The defense in that case has twice requested a mistrial, once over the prosecution's line of questioning, another time for the video quality of a key piece of drone footage, but those requests have been denied. So does that come into play at all when this verdict is reached?
It comes into play in the sense that if the verdict comes down as guilty, those will automatically become appellate issues. So the defense team would bring up the exact same issues on appeal if there's a guilty verdict.
Let's turn now to the trial over the death of Ahmaud Arbery. One of the suspects, Travis McMichael, was cross-examined by the prosecution yesterday. What do you make of this decision to have him take the stand? It's something we don't often see with a defendant in a high-profile case like this. And what did you make of his testimony? Did it help him or hurt him?
Well, I believe that it hurt them. I don't see a defense in this case. I've been studying the law on that, and a private person can make a citizen's arrest if the offense is committed in their presence or immediate knowledge. And he testified that neither of that happened. So therefore, he's saying, I didn't have the right to perform a citizen's arrest. And if he didn't have a right to make a citizen's arrest, then that gives Mr. Arbery the right to actually use self-defense. So when Mr. Arbery ran up to him to punch him or grab the gun, he was justified in doing so and shouldn't have been shot for doing so.
Okay, well, we have closing arguments set to begin next week, as we talked about with Katie. What are you going to be looking for? What do you think the strongest points are that the defense can make and that the prosecution can make? Because basically they're pitching to the jury and sort of instructing them on how to fill out the ballot box here.
Of course, yes. Well, I think the defense is going to do one of two things. They're either going to kind of show their cards finally that, ladies and gentlemen, we know they're guilty, but they're not guilty of first-degree murder. They thought they had a justified case of self-defense. As it turns out, they legally didn't. But so you shouldn't convict on first-degree murder. Or they're going to stick with justified self-defense, which legally I don't think is a winner for them. The prosecution has a great case. They just have to read the law to the jury and reiterate the facts and say, ladies and gentlemen, Mr. Arbery was gunned down for jogging the street, running past houses of people who were suspicious of him, and he shouldn't have been killed for that. And because he was killed, that is a case of first-degree murder.
All right, we'll see what happens. Joseph Tully, thanks for your analysis this morning. We appreciate it.
Yeah, thank you for having me.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.